Good afternoon. This is Colorado Oil and Gas Conservation Commission. It is February 27th, the Monday afternoon. We have a meeting scheduled at this time. We will take a roll call.
Thank you, Mr. Chair. Commissioner Ackerman.
Present.
Commissioner Bogue. Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. This matter was teed up for an executive session on docket 221000381 involving Vision Energy. I would also like to tee up an executive session for docket 201100261, the KPK matter, which we have on our agenda later this afternoon. With that, I would look to AAG Davenport for next steps.
Thank you, Chair. The next step is for me to read my script on executive session and the commission to have a motion and vote on whether or not to go into executive session. Commissioners, at this meeting, the commission is authorized to go into executive session for the purpose of receiving legal advice and analysis as authorized by 24-6-402-3A Roman 2 regarding 2 matters. The commission's review and consideration of docket number 221000281 for the plugging and abandoning of wells owned and operated by Vision Energy. That matter was noted on the agenda today. The other matter, which is on the agenda for today, though was not specifically noted in the executive session, is for the commission to receive legal advice and analysis on KP Kaufman Company, Inc.'s motion to reconsider and stay order in docket number 201100261. The fact that it was not specifically noted on the written agenda is not a problem. The commission may choose to go into executive session for matters that it is considering on agenda. But with that, Mr. Chair, I would encourage, or I would ask you to encourage a motion to enter into executive session for the matters and purposes I just named.
So encouraged.
So moved. Second.
Motion and a second to go into executive session. All those in favor signify by saying aye. Aye.
Aye. Aye.
Any opposed? Okay, folks, we're going to go into executive session. What that means is we will leave this Zoom meeting. The commissioners will reconvene in executive session in a different Zoom format. We will return to this Zoom meeting after we're done with executive session. I would anticipate maybe 30-40 minutes or so. You are encouraged to stick around and you can watch us come out of executive session once we're done. We will not be taking further action at this time. So with that, we will see you in 30 to 40 minutes. This is the Colorado Oil and Gas Conservation Commission. We have returned from executive session. I would recognize Attorney General Kyle Davenport.
Thank you, Chair. Commissioners, during the executive session, the commission received legal advice and analysis regarding 2 matters. The commission's consideration of docket number 221000281 for the plugging and abandonment of wells owned and operated by Vision Energy. That matter was stated on the written agenda for today. The other topic of executive session was to receive legal advice and analysis on KP Kaufman Company, Inc.'s motion to reconsider and stay order in docket number 201100261 at all. That matter was not noted on the written agenda, but it was reasonably anticipated for executive session today and requested by the commission at the beginning of this hearing. Commissioners, no decisions were made and no votes were taken in the course of this executive session. Mr. Chair, I would ask that you encourage a motion to exit executive session.
Looking for a motion to exit executive session.
So moved. Second.
Motion and a second to exit executive session. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Okay, we are out of executive session. Anything further, AAG Davenport?
No, Chair, thank you.
Okay. All right, commissioners. Well, welcome back. We are in our normal, or not a normal, but we're in a business meeting this afternoon. We are taking up docket 201100261. This involves KP Kaufman. We have before us a motion filed by KP Kaufman It's entitled KP Kaufman Company's Motion to Reconsider and to Stay the Written Order of February 15th, 2023. We also have a response filed by staff to that motion. We are set this afternoon for oral argument on the motions. Pursuant to the hearing order, each party has 15 minutes to make their argument. Either party can, or I guess, Mr. Jacobs, if you would like to reserve a certain set of time for rebuttal, if you would let me know ahead of time so that I can let you know when you're getting close to your time. With that, before we move into the oral argument stage, Mr. Jacobs, do you have anything further procedurally?
No, I do not, Mr. Chairman.
Ms. Stafford, do you have anything further procedurally?
Just a brief clarification, Chair. I believe the agenda indicates that staff is supposed to be going first here, and then KPK will go second. So just with your statement there about reserving time for rebuttal, I'm wondering if that needs to be adjusted.
Sure. I'm sorry, I don't have the hearing officer order in front of me, and I looked at it briefly, ever so briefly last night. So apologies for that. So Ms. Stafford, you're going first, and Mr. Jacobs, you're going second, and then staff, are you
If I may,
possibly? Just a
Mr.
second.
Chair,
I'm going to recognize you. Give me just a sec. So I'm a little confused. It seems to me that it's KPK's motion, and so I'm wondering why it is that they're not going first, if someone can help me. Mr. Jacobs, and then I'll hear from staff.
my point exactly, we're the movement. It's our motion. We should go first. I can reserve some time for rebuttal, and I intend to do so.
Ms. Stafford, did you want to weigh in on that? And AG Davenport, thank you for visualizing yourself.
I have no argument. My only statement was that on the agenda, it reflects that we're going first. And I just wanted to make sure that we got ourselves in order. Staff is prepared to go wherever we are told to go.
Okay. All right. Then let's allow Mr. Jacobs to go first. He's the movement and bears the burden. We'll have staff do a response. And then Mr. Jacobs, if you desire any rebuttal time and you've reserved it, we'll give you that opportunity for rebuttal. Does that sound fair to everybody? Mr. Jacobs, is that fair?
That is acceptable. Thank you.
Is that acceptable, Ms. Stafford?
Yes, thank you.
All right. Mr. Jacobs, do you want me to alert you to any setup time for rebuttal?
I would like to reserve 3 minutes for possible rebuttal. So as I approach the 12-minute mark, if I could get a notice of that, I may use an additional minute of that for my argument in chief, but I'd like to reserve 2 to 3 minutes.
Okay. I'll wave my hand when you get to 12 minutes and then we'll stop the clock and you can make a call at that point. Is that fair?
That sounds good. Thank you.
Okay. Anything further from commissioners before we get going here? All right, seeing none. Mr. Jacobs, you are recognized.
Thank you, Mr. Chair. John Jacobs for KP Kaufman Company, Davis, Graham, and Stubbs. Good afternoon, commissioners, Chairman Robbins. Thank you for the opportunity to argue this motion on an expedited basis, and thanks to staff for their filing of a response on an expedited basis as well. KPK respectfully moves the commission to reconsider its order finding no substantial compliance dated February 15, 2023, and to stay most or all of its sanctions for 6 months in order to, 1, prevent irreparable harm to public health, safety, welfare, and the environment, including wildlife resources, prevent irreparable harm to KPK's business viability, essential operating revenue, customer and vendor relationships, and leasehold mineral property rights, and simply make it possible for KPK to comply with the commission's order and avoid the revocation of KPK's license to operate in Colorado. Such reconsideration and requested stay would also facilitate KPK's efforts to sell the Spindlefield assets and locations to another major Colorado operator, a process which has been significantly hindered by the commission's recent order. As you should know from KPK's motion, it is impossible to comply with the order as written. This conclusion is compelled by multiple aspects of the order, including the immediate suspension of KPK's certificates of clearance prevents KPK from transporting or selling its oil and gas production, and therefore denies KPK the operating revenue it needs to pay its employees or third-party vendors, to engage in the shut-in of all of its wells and flow lines, which will include draining of hundreds of tanks and hundreds of miles of flow line, adequately maintain the wells and flow lines it does manage to shut in, or complete remediation efforts necessary to protect public health, safety, welfare, and the environment. The imposition of $1,900,035 in previously suspended civil penalties, which this commission has previously found based on unrefuted expert testimony that KPK is unable to pay, and by depriving KPK of its primary source of revenue and imposing an enormous civil penalty it knows KPK is unable to pay, the commission effectively ensures that KPK cannot sustain the operations necessary to comply with the order. The commission must know that by imposing these penalties, KPK will not be in full compliance with all commission rules by August 1st, 2023, and therefore will lose its license to operate. Perhaps most importantly, the order increases the risk of harm to public health, safety, welfare, the environment, and wildlife resources by effectively requiring the immediate shut-in of all of its facilities. KPK does not have the capacity or infrastructure to store its oil and gas production on site. So the order effectively requires KPK to immediately shut in all of its facilities in Colorado. Moreover, without operating revenue, KPK will soon be unable to perform necessary maintenance and monitoring of these facilities, especially for wells and facilities not associated with the 70+ sites previously subject to the compliance plan agreement. Nor will KPK be able to complete remediation efforts necessary to protect public health, safety, welfare, and the environment at those 70+ sites. As the commission previously heard at the hearing in this matter, it is undisputed that KPK has carefully accounted for the over $7 million it has spent in the last 14 months investigating and remediating these sites. KPK's vast network of oil and gas facilities are comprised of a steady state, low pressure, constant flow system in the Spindle field that has never been completely shut in. KPK must first prepare a detailed plan for systematically shutting in its flow lines, ensuring that upstream flow lines are evacuated first to avoid overpressurizing and cracking the flow lines. Developing the outline for this plan, which KPK has begun, will take time, at least another 10 to 15 working days. But once that plan is available, then KPK pumper crews must manually shut in the separators, drain the tanks and flow lines, and shut in the meter inlet for gas gathering at each KPK location. It will take many months and perhaps longer to safely shut in KPK's 1,250 wells across the state. By ignoring these facts and effectively requiring the immediate shut-in of these facilities, the order poses the following threats to public health, safety, welfare, and the environment. The imminent risk of freezing damage to flow lines and water injection lines at various KPK facilities if immediate shut-in were attempted, including on BLM federal leases in the McCallum and Battleship fields in Jackson County. The risk of tank overfilling and shut-in operations as shut-in operations progress without the ability to sell oil removed from tanks and also from hundreds of miles of flow lines. The lack of maintenance and monitoring required on a nearly daily basis, even after shut-in, to confirm flow lines are not repressurizing and that seals on isolation valves are holding against much higher reservoir pressures not normally encountered during regular low pressure flow conditions of the Spindle field. And the 5 months or more of time before staff apparently intends to mobilize available state contractors to assume these necessary obligations if the order is not stayed and KPK is thereby disabled from attending to its almost 1,250 active wells and hundreds of miles of flow lines. Staff incorrectly asserts that KPK's ability to pay is merely professed and not established in the record. They cite to pages 34 and 35 of the order for the proposition that the commission rejected KPK's economic arguments, but these are not merely arguments. KPK produced unrefuted expert witness testimony and evidence of KPK's financial condition and ability to pay. Indeed, KPK was extremely forthcoming regarding its financial condition, providing confidential business information to the commission and engaging in extensive questioning about its financial condition in executive session so as to protect that information from potentially damaging public disclosure. Staff proffered no contrary evidence or testimony whatsoever, not in January, not in June of 2022, and not in August of 2021. Indeed, staff took no position on the issue of ability to pay in all prior hearings in this docket. It cannot be heard to now say that KPK merely professes to have an inability to pay based upon a recent finding of this commission that lacks the support of substantial evidence in the record. Staff also incorrectly argues that all available sanctions being imposed was agreed to by KPK or required upon a finding of noncompliance with the CPA, but that is simply not the case. The CPA lists available sanctions that may be imposed in the event KPK is found to not be in substantial compliance with the CPA's Section 4 requirements. And while KPK respectfully disagrees with the Commission's finding of no compliance, the sanctions available are not an all or nothing proposition. Chairman Robbins, Commissioners, they are simply a listing of the sanctions available after any finding of pattern of violation, as noted in the order finding violation itself, not just in the CPA. And they are listed therein in the disjunctive, using the word or between them in commas, indicating that one or some or possibly all such sanctions might be imposed by the Commission in the exercise of its enforcement discretion and in accordance with the Oil and Gas Conservation Act, the Commission's own rules, and its penalty policy. So for staff to argue that this excessive collection of sanctions imposed by the Commission completely and entirely by its order of February 15, 2023 was somehow agreed to by KPK is simply disingenuous. This commission still needs to right size its sanctions under its own rules and penalty policy, as well as federal and Colorado law regarding excessive penalties more generally. Staff acknowledges that it will not have access to KPK's facilities under the Orphan Well Program until August 1st of 2023 in their response, but they say nothing about the likely condition of those facilities in the absence of necessary monitoring and maintenance in the interim. Staff only argues that KPK remains responsible for compliance, but without the ability to sell its production and hence no revenue, and with a $2 million penalty imposed on it to boot, this assertion is implausible on its face. Staff also argues that KPK's obligation to continue to operate in compliance with the Commission rules somehow allows it to not shut in immediately and to sell its production while it prepares and implements a shut-in plan, but this is not supported by the plain language of the Commission's order. And staff's concern about the absence of a KPK plan to shut in having been shared to date is perhaps ironic, especially given that KPK produced multiple CPA-required plans for staff at very significant expense, all prepared timely, all but one approved by staff and not even commented on prior to the recent order. And despite express language of the CPA not permitting the imposition of penalties in those circumstances, this commission found no substantial compliance with those plan requirements in Section 4. The staff insistence upon a shut-in plan from KPK just 7-8 working days following the final written order is particularly vexing, given this commission has previously accommodated other operators facing similar sanctions. Indeed, in 2015, the commission and Director Murphy approved a plan associated with another producer, Noble Energy, Inc., having to shut in over 1,000 wells in response to EPA enforcement action, a process that took Noble and the staff many months to plan and years to fully implement. Finally, staff's access to significant orphan well program funds is no guarantee of better maintenance, abandonment, and remediation of KPK's facilities, and the orphan well program is full of sites that have languished on those lists without significant contractor attention for many years. money was only one of the missing ingredients previously. And this commission is essentially betting the health, safety, welfare, and environment will be better served by an untested but well-funded orphan well program, replacing 150 employees at KPK with nearly 39 years of knowledge and experience in operating its unique assets. For all of the foregoing reasons, KPK respectfully urges the commission to grant the motion, holding the order of February 15, 2023 is stayed with respect to the suspension of certificates of clearance for a period of 6 months, with respect to the demand for payment of $1,935,030 in penalties otherwise due by March 18, 2023, also for a period of 6 months, with respect to the requirement to shut in all KPK wells and flow lines until April 3rd, 2023, with provision for extending this stay for good cause shown, and with respect to revoking KPK's license to operate for a period of 6 months. Thank you.
You're muted, Mr. Chair.
Thank you. All right, thank you, Mr. Jacobs. I believe now we will hear from Ms. Stafford.
Thank you, Chair Robbins. Commissioners, KPK effectively asked this commission to temporarily rescind Order 1B863 and allow KPK to continue operating as if its operations do not threaten and cause impacts to public health, safety, welfare, the environment, and wildlife resources on a daily basis. Staff largely rests on its written response to KPK's motion, but here are some of our main points. First, KPK did agree to this relief as set forth in the CPA. It mutually reviewed, negotiated, and signed on to this potential relief. Second, KPK alone is responsible for compliance here. And if KPK cannot comply, staff is prepared to step in. Third, it is possible to comply with the order if KPK tries. Instead, KPK continues on business as usual without a decision in their favor from this commission as required by the APA. And fourth, KPK has not shown irreparable harm will actually result with the commission's relief as ordered in Order 1B863. Staff instead would like to use the time it has been allotted today to elaborate more fully on some of the facts related to operational concerns, that inform our position on KPK's motion. At this time, I want to turn it over to Mike Leonard, Staff's Compliance Manager, and then to Director Murphy.
Mr. Chairman, if I may. It was my understanding that this was oral argument and each side was to be given 15 minutes to present argument of counsel. Are we reopening the record? I have not heard any such action taken by the commission.
All right, let's stop all the timers. Ms. Stafford, what is your position relevant to bringing in witnesses as opposed to oral argument from counsel?
Thank you, Chair Robbins. It was staff's understanding that we had some flexibility to decide on how we would be presenting our argument here today. We wanted to rely on some of the facts, at least, that were set forth in KPK's motion and discussing those, pursuant to the commission rules under Rule 501. The rules are liberally construed. Rule 510 allows each party to present their argument essentially as they see fit. And finally, under Rule 517C, the commission has discretion to take administrative notice of staff or commission documents and records or matters within expertise of the staff. And I would respectfully defer to staff's expertise on some of the finer points that KPK makes in its motion.
Mr. Jacobs, response?
Well, I renew my objection. We've had no prior notice of this. We're certainly familiar with staff's relaxed approach to the rules, its own, the rules of civil procedure, the rules of evidence. We don't like that approach, and therefore we object. I've had no prior notice of this.
All right, let's take 5 minutes, and I will be, when I come back, we'll we've got the situation where staff was desirous of bringing in the best I can call them is witnesses to testify. I believe that I'm going to rule that I'm not comfortable with that at this stage. This was set forth for oral argument. I do note that the hearing officer order did not preclude staff relying on others to provide that argument, but I'm not comfortable with that. And so I'm not going to allow the director or Mr. Leonard to testify or to provide that oral argument to staff to the extent that you believed you had the ability to present your case that way. I will grant you time to get prepared as counselor for the commission staff to be able to present whatever argument it was that Mr. Leonard or Ms. Murphy were going to do so. And if that means we need to hold the hearing in abeyance or continue the hearing to tomorrow, I'll be happy to do that. So that's the place I'm going to go with this. Ms. Stafford, do you desire to have some time to work with your client so that you can be adequately ready to prepare the remaining part of the oral argument on the motion?
No, thank you, Chair Robbins. I'm prepared to go forward.
Okay. All right. Mr. Jacobs, do you have anything procedurally further? I see you're unmuted.
No, thank you, Mr. Chairman.
Okay. All right. Oh, hold on. The timer's out of order as well. Okay, so I'm going to start the clock again, Ms. Stafford. I believe you've used, I think, 2 minutes and 52 seconds. So with that, we would recognize you for additional argument on the motion.
Thank you, Chair Robbins. I will pick up where I left off, and I appreciate the consideration. Now, KPK's motion is largely comprised of factual assertions related to the, quote, immediate need to shut in. As I mentioned previously, staff largely rests on its written response, but would like to make some key points in opposition to KPK's assertions. First, in KPK's motion, they refer to their assumption that staff does not have a plan to address their fields should the need arise. As we set forth in our response, we are prepared with a preliminary plan to deal with those necessities as they arise. Now, KPK has not provided a plan to manage the facilities upon the suspension of their Form 10s. And as I mentioned, KPK asserts staff doesn't have a plan to manage these facilities either. But what we were looking to see from KPK here with respect to a plan, the elements of a potential shutdown plan to comply with the language ordering them to stop sales due to the suspension of their Form 10s. A phase 1 plan would reduce the acute risks. First, we'd shut in wells at the wellheads using all available valves in place. Pump jacks would be placed in the down position to alleviate possible polish rod liner failures. We depressure the flow lines at the tank battery, depressure separation equipment, remove water from the separation equipment and tanks to prevent freeze breaks, and lock out and tag out valves to prevent inadvertent opening. The second phase of staff's plan would be to reduce ongoing risks. We would isolate the wellheads from the flow lines by physically disconnecting those, removing fluids from the flow lines, removing hydrocarbon fluids from tanks, and continue the routine inspection of facilities. Now, COGCC has vast experience in shutting down active fields. KPK has asserted that staff does not have such experience. But keep in mind that COGCC field staff has multiple decades of experience with oil and gas operations and can oversee these phases. Staff has the ability to shift personnel to focused activities. Now, secondly, I want to move to another contention in KPK's motion that discusses I would like to move to the next piece where KPK asserts it is, quote, impossible to comply with the order as written. As staff asserts in its response, it is not impossible to comply with the order as written, as the order provides a flexibility for KPK to address necessary shutdown plans, however it needs to manage its facilities in a manner that protects public health, safety, welfare, the environment, and wildlife resources. The written order provides such flexibility. Now, I want to speak to a few key points in the in staff's response that we have noted. Since Wednesday, February 22nd, 1 week after the written order was issued, field staff performed inspections to verify compliance, and staff found just over 20 separate locations to date with recorded gas sales and 1 location where oil was being transported for sale. You will note that staff attached many of these inspection reports as Exhibit 1 to its response. Now, some of these had multiple gas sales points. And as you can see in many of the photographs that were attached to the inspection reports, it shows that sales were recorded for those days. It's a sales meter digitally displaying sales volumes for the current day and the day before. In another photograph that's attached to one of the inspection reports, there is a photo of the digital manifest for the trucking company that was transporting oil. As you know, KPK is required to maintain compliance with COGCC rules. I'd like to pause for just a minute to get my second piece of note up. I seem to have lost my screen.
Let's halt the time.
Oh, okay, thank you. I'll begin again, I'm sorry. Now, we are currently assessing compliance with some of the most serious consequences the Commission can impose, and the Commission did not impose these easily or at the drop of a hat. As you know, the enforcement hearing on this matter began in 2021. It is KPK's responsibility to come into compliance with the Commission's order, the act, and the rules. And focusing on staff's capacity avoids this fact. Without a specific plan to come into compliance with the Commission's order, it is unclear how KPK's request for additional time and a stay of effectiveness of the order for 6 months will put them in a better position to achieve compliance with this order, the rules, and the act. Now, on this coming Wednesday, it will be a month since the Commission made its oral findings on February 1st, and nearly 2 weeks since the written order was issued. KPK's conduct during this period of time is concerning. The compliance team observations, as I detailed previously, are quite troubling. KPK's motion identifies perceived operational risks, but doesn't set forth any concrete steps on how KPK will accomplish compliance, even if their Form 10s are reauthorized. The order already allows for coordination with staff that KPK seeks with its motion. And the language of the order provides a space for the orderly and measured shut-in of wells, if that is what needs to be done to operationally to reduce the risk to public health, safety, welfare, the environment, and wildlife resources. The order only suspends their Form 10s immediately. Based on what we've seen from this operator in recent years, staff has well-founded concerns that additional time will only exacerbate the risks posed by KPK's continued operations. Again, as an operator in this state, KPK is responsible for operating in compliance with the Act, the rules, and the Commission's order. Staff outlined how we plan to manage the potential consequences of KPK's noncompliance. And while an important consideration, it avoids the point that KPK remains responsible for operating in compliance with the Act, the rules, and this order. As I just pointed out, staff has the expertise and the understanding of the steps necessary to manage both acute and ongoing risks. Staff's response sets forth our preliminary strategy, which continues to evolve as we gather more information. Staff understands that these are challenging circumstances for KPK to find themselves in, but their proffered solution here to pause the imposition of relief while they continue normal business operations is not an appropriate solution given the recent findings of this Commission. Thank you, Chair.
All right, thank you. Ms. Larson, how much time does Mr. Jacobs have for rebuttal?
There we are. 1 moment. Mr. Jacobs used 12 minutes and 6 seconds, so he would have 2 minutes and 54 seconds remaining.
All right, Mr. Jacobs, you have 2 minutes and 54 seconds for rebuttal.
Thank you, Mr. Chair. I don't think I'll need all of that. Appreciate staff's response and your prior ruling. I would simply point out that without revenue to be able to conduct the work that is necessary, even the shut-in work required by the order finding no compliance, we will soon lose our business viability, and that is irreparable harm under applicable case law. We have had 10 employee resignations since this commission's verbal actions and final written order in February. We're doing our best to maintain vendor relationships. We have some strained relationships with vendors under these circumstances as well. So it is a situation that quickly sort of feeds on itself, and the recognition by this commission that the order works that kind of irreparable harm on KPK and its ability to comply, consistent with the commission's prior finding of ability to pay, I think is important to the motion. With that recognition and reconsideration, allowing us to sell our oil and gas to fund the necessary work, even to shut in over time with a plan that we are working on, that we can make available to staff in the near term. That is the relief that we're requesting today, consistent with the proposed order. We think that it is appropriate. We think it is also protective of public health, safety, welfare, and the environment. And we therefore respectfully request that you grant the motion to reconsider and to stay on that basis. Thank you.
All right, commissioners, we've heard oral argument. Does any commissioner have questions for Mr. Jacobs? And then I'll do the same thing. Questions for Ms. Stafford. Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Jacobs and Ms. Stafford, for your continued due diligence. I think this is for Mr. Jacobs. I'm trying to understand, if we were to grant you what you're asking, what does everything look like in 6 months?
I think in 6 months, we're able to develop a shut-in plan, implement the shut-in, hopefully in a tailored manner. We would prefer to shut in the facilities that pose risk and not all other facilities. I think your own comments during deliberations on the first were appropriate. There are many facilities that are not the subject of the CPA's requirements, that weren't among the 70+ locations that were the focus of the CPA, and the ability to obtain operating revenue from the sale and transport of oil and gas from those locations is essential to the continued viability of the company. So in 6 months' time, I think that would enable shut-in planning, shut-in plan implementation. It would also allow for some of the efforts to transact business in the nature of a sale of the Spindle field to go forward. Those transactional efforts are greatly hindered by the commission's recent order.
Thank you. I'm trying to think of a delicate way to say this, but how would we ensure that we wouldn't have deja vu all over again and just be right back here in 6 months because you were unable to agree on a shut-in plan with staff, or something unanticipated happened, and so therefore, significant numbers of sites have not been shut in, etc. I think I'm struggling with accountability.
Well, I did not terminate the compliance plan agreement, and I think the compliance plan agreement held us very accountable. But in its absence, I can understand your concern about accountability. So maybe we need structure. In my closing argument, I did say we can make mid-course corrections on the CPA, but throwing it out the window was not necessarily the best alternative. I'm not asking you, because it's outside the scope of my motion, to reconsider the termination, but I am saying we had accountability.
Thank you. Does KPK have an emergency shut-in plan? So there was, floods similar to 2013. They must have some sort of plan in place to quickly shut things in, do they not?
We have plans and capability to shut in typically a discrete area. I'd say the largest challenge was under the April 2021 901A order, and we did promptly comply with that with some measure of trepidation, again, because this system was designed to flow. It has always flowed, and it does not normally expose its components to reservoir pressures. It operates in the 30 to 50 pound region or range. And reservoir pressures, as I think is indicated in our motion, are upwards of 400 pounds. So to do it for all 835 wells in the Spindle Field, which I'm talking about, for all other hundreds of wells in our other areas that comprise the 1,223 wells at issue, that is of great concern. And each area is going to have its own sort of sub-plan. There are some standard procedures, but we're developing specific procedures for each of those areas. Some are water flood operations that are pressurized, that need to depressurize, and that are at greater risk of freezing in the winter weather because of the water injection.
Okay, thank you.
Commissioner Cross.
Thank you, Mr. Chair, and thank you, Mr. Jacobs. I just wanted to ask a couple quick questions to clarify. First off, in response to Commissioner McGowan's questions there, I believe you said the shut-in plan that you would propose to develop and implement within the next 6 months would only shut in some of the wells, some of the more worrisome wells. Is that what you said?
Our proposed order, which is filed with our motion, asks that only the 70 plus locations, the 901A orders, remain shut in and subject possibly to suspension of certificates of clearance, that other wells be allowed to produce to provide us the production revenue we need to engage in other activity, shut in or otherwise.
So I just want to understand, big picture speaking, during the 3.5 days of hearing in January and our ultimate ruling in February, the commission found that not only is KPK not substantially complied with the CPA, but in addition that despite claims to the contrary, there is not I think you called it a culture of compliance, that we're continuing to see issues arise with respect to spills, with respect to reporting issues and everything else. And so even though we had that finding, you still want to have KPK be able to operate all wells where there just isn't a spill currently going on, and just have certificate of clearance removed for those wells that were specifically part of the CPA. Is that correct?
I think that is correct, because I think we need that revenue to continue our remediation, even to conduct shut-in activities, and to bring ourselves into compliance with the rules, which are required by your order by August 1st of 2023.
Okay, and then the next question I want to go into is the issue of the potential sale. And the sale has been brought up several different times. And I believe even in your responses to Commissioner McGowan's comments there, you didn't say that a sale would be impossible. You said a sale would be hindered if the order went through as is. Can you explain to us quite clearly, is a sale still possible with this order in effect?
I think it's greatly complicated. One of the three operators that our clients engaged firm, Petrie Partners, has approached and met with and negotiated with, has said in light of the order, they're going to take a pass, at least for the time being. So it's already caused one potential purchaser to withdraw from discussions with our representative, our marketing
You
representative.
still have potential purchasers
There are two others to my knowledge, perhaps another. I don't know for sure. I'm not directly involved, but one I do know has withdrawn from the discussions in light of your order.
But there's nothing legally that would prevent a sale from happening or that would prevent KBK from being able to utilize those assets through a purchase and sale agreement because of the order.
I don't know that I necessarily agree with your question. I know it calls for a yes or no answer, but I do believe that transactions require certainty, and there's a lot of uncertainty injected into any transaction by virtue of your order.
Is it legally possible?
Well, I think it's legally possible to sell some of the operating assets of the company, notwithstanding the order. I don't know that it's probable.
Okay. And then the other thing that I wanted to double check on is you said that during the first part of your oral argument here, that the commission needs to, and I believe the quotation that I have from you, correct me if I'm wrong, is right size its sanctions. Can you please provide a little bit more information on what you mean by right size its sanctions?
I believe that that is shorthand for the kinds of considerations of mitigating and aggravating factors that are expressly provided in the Commission's enforcement and penalty policy, which is similar to many regulatory agencies' civil penalty policies. And that is the basis of prior testimony provided in 21 and 22 by KPK regarding ability to pay and why a major portion of the penalties assessed in 2021 should be and were suspended. That's what I mean by right sizing the penalty. Ability to pay is an important factor to consider in right sizing the penalty. I hope that answers your question, Commissioner.
So you're more focused on the ability to pay, not the fact that the penalty itself as initially assessed was improper.
The penalty was assessed based on certain alleged violations that were found, a pattern of violations that was found, looking at your penalty matrix and all of that. But then it was adjusted in light of ability to pay. It was never imposed in its entirety. And to now impose it in its entirety, regardless of ability to pay, frankly, violates your own enforcement and penalty.
Was it adjusted or was it suspended?
I think that the suspension, partial suspension was made and in light of ability to pay and consistent with your policy. And I would argue that the full penalty being imposed without regard to ability to pay is violative of your own policy.
But I'll ask again, were those penalties suspended or were they adjusted?
They were suspended by this commission after finding a larger penalty without regard to ability to pay.
And is by a penalty being suspended, does it mean it could not be reapplied?
No, it does not, but it should be reapplied consistent with your own policy.
Okay, and then finally, I want to go into just the reconsideration aspect of the request as opposed to a request for a stay. What facts do you think the commission ignored, or what legal aspect are you saying the commission got wholly wrong that justifies a reconsideration here?
Well, I do think that some of the concerns about freezing, overpressuring, potential for spiller release associated with shut-in or a hasty effort to shut in are factors that perhaps were not fully considered by this commission in making its ruling and issuing its written order of February 15. And so I do believe that that presents this commission with information to reconsider its ruling.
So you're saying the new arguments that you're bringing that justify reconsideration are simply that we should consider an automatic shut-in, a quick shut-in here because of the environmental and maintenance dangers.
No, quite the contrary. I'm saying you let Noble work for months and even years to shut in 1,000 wells and deal with the consequences of that. And that is the best example of how to do that safely, thoughtfully, over time. And having done it before, you might want to consider doing it again. It worked.
So now the new facts that we didn't consider is something that happened 7-8 years ago with Noble, not something dealing directly with this case. Because I'm just trying to understand, with reconsideration, we either ignored facts or we got something legally wrong.
It's the most analogous situation of which we're aware in an order, an AOC signed by the director and approved by this commission involving over 1,000 wells being shut in. I think that's pretty strong parallel.
I'm not asking about a parallel situation. I'm saying, what facts did this commission ignore, or what legal argument did we get wrong that justifies the reconsideration here?
Well, I think it's both the concerns expressed in the motion regarding freezing, overpressurization, potential for spiller release from an abrupt or hasty shut-in, as well as the time necessary to shut in so many wells, as indicated by the Noble Energy Inc. AOC.
Okay, that's my only questions for now. Thank you, Mr. Chair.
Thank you.
Are there other questions from commissioners? Commissioner Ackerman?
Thank you, Mr. Chair. Thank you for the testimony so far. Appreciate the many points of clarification. I have a couple of questions and then points of follow-up, and this is directed at you, Mr. Jacobs. AG Stafford brought up during her presentation that, and the appended forms to staff's response demonstrate that KPK continues to operate outside of compliance by selling gas after explicitly ordered not to, as well as bringing a truck on site to transport oil. Can you respond to that and talk a little bit about, to me, that's a direct and blatant violation of the order directly after, and would like to hear your thoughts on why that's continuing to occur.
I'm happy to respond. Again, we're working on a plan to shut in. If one shuts in hastily, abruptly, we believe that there is an increased risk of spiller release for many of the reasons stated in our motion. Gas flowing helps move fluids. This is three-phase fluid: water, oil, and gas. Turn off the gas and much of the non-gaseous fluid doesn't move in parts of the spindle system in particular. If it doesn't move in this weather, it can freeze. It can freeze and crack lines and cause a spiller release. So until the plan is developed and implemented thoughtfully and carefully, shutting in gas at the meter inlet or wherever is premature and unwise. And as far as sale of oil, I believe one example was mentioned by Ms. Stafford. Oil can overfill a tank and spill onto the ground. And before gas and oil are shut in, again, to avoid the risk of freezing and other spills or releases, not following a thoughtful and careful plan to shut in, one needs to empty tanks before they overfill. That is the sum and substance of why those sales have occurred, and there is no other reason. It is not in disregard to this commission's authority or directive. It is out of a regard for safety and implementing the proper, thoughtful shut-in plan so as not to result in still more spills or releases.
Thank you, Mr. Jacobs. I do understand your argument that that KPK disagrees with that action and would prefer a different approach. Would you say that KPK communicated with or coordinated with staff with regard to the continued sale, or was this discovered by staff and then KPK was approached?
Staff has approached KPK personnel on a couple of locations during some of these inspections. They have reported back to KPK management. I believe a simple statement was prepared to provide employees in the event of staff encountering them in future such inspections, that until we have the plan to shut in, we believe it safer to allow the system to flow, to not overfill tanks, to keep fluid moving so that we can, in an orderly fashion, start to shut in at the right locations, not overpressure portions of the system, and work our way through the system, in the case of the spindle field in particular, to a successful completion of that effort.
Thank you, Mr. Jacobs. And I understand the approach there. My question is associated with, did KPK just continue on, or did it contact staff and say, hey, listen, we think your plan is so unwise. In order to clear lines, we're going to continue to sell gas and oil, or did it just continue to do so?
There was no statement of intent to allow it to continue, but its staff, KPK personnel, Mr. Meese, our EHS compliance executive director, met with staff on several occasions following February 1. And he met with Mr. Duranlo and I believe others, and they spoke about initial activities, both backfilling activities in light of the commission's ruling on February 1st, as well as developing a plan to shut in safely. And that is ongoing. We've met, I believe, on 3 occasions. I could be wrong, but I think there were 3 meetings.
Thanks for your response, Mr. Jacobs. Shifting gears just a little bit and recognizing a point that you made today and previously during our previous hearings, that whole field shutdown is complex and difficult. Can you provide or estimate the length of time it takes KPK currently to shut down just a standard individual well in the event of some event currently?
I can only speak from the draft text of plans and considerations that the company has made. They have 2 vac trucks. They need to start with the isolation valve at the furthest most upstream wells. They then need to evacuate flow lines, separators, tanks. In the case of flow lines, some of them may not completely evacuate due to low spots and it being a low pressure system. In order to fully remove fluids from a line, one might need to dig and excavate and actually cut the line at the low spot to remove fluids. So depending on the well and the circumstances, it could take several days, even longer. I'm somewhat speculating here, but those are the steps that I'm aware of for even just a single well being shut in.
Gotcha. And so KPK does not have any remote shutdown equipment or anything like that. It's operating under the vac truck approach.
I don't know that we have remote shutdown capability on the spindle field system. We may elsewhere, but I don't know that as I sit here, so I can't speculate, Mr. Commissioner.
Thank you. I appreciate that. And a lot of the argument that we've talked about today also talks about this kind of chicken and the egg, in that KPK would like to continue to wisely shut down at least a portion of its assets under reconsideration, but doesn't have the revenue to do so in the event that it can't sell products. Can you clarify, if it's appropriate, that KPK are the only assets it has the assets that we're talking about in question here, or does it have revenue from other assets or other cash reserves? Does it operate hand to mouth, I guess is what I'm asking.
Well, I believe that this was the subject of testimony by the company in prior hearings before you assumed your position as commissioner. It is a hand to mouth, cash flow constrained business at present, even with improved oil prices and gas prices. The company has no secured debt. It paid off a substantial amount of secured debt a number of years ago, but it is cash flow constrained. It owns hard assets. It has proven reserves under its leases. It has its leases, which are mineral property rights. Those all have a certain value, but it's illiquid. And the ability to transact to divest of some of those assets is what I was speaking to earlier in terms of the complicating factor of your order and the company's efforts to sell the Spindle Field, for example.
Thank you for renewing that testimony for me. I appreciate that. And finally, and then this has been kind of asked, but I have a little bit of a different approach here in that what I'm understanding is that your proposal is to grant extended time to develop, implement a shut-in plan, but only for those facilities that are in question, and then that KPK would continue to operate its other existing facilities. Are you open during this hearing to discussion about an extended time to develop and implement an entire shut-in and shut-down plan? Or is that something that's not under consideration or has been discussed between you and your client?
We've not discussed that. I'm not prepared to ask for that. I'm only prepared to ask for the relief requested in the motion and the proposed order today, Mr. Commissioner.
Thank you for answering my questions, Mr. Jacobs.
Other questions from commissioners? Commissioner McGowan.
Yes, thank you, Mr. Chair. Thank you for your indulgence. I think I would like some clarification about which under this request, which wells we're working on to shut in. And I think I heard you say, Mr. Jacobs, the 901A remaining shut in, but I think that list is actually smaller than all of the projects that were reflected in the CPA. And so maybe I'm not understanding. So if you could clarify that. And then last time we were in deliberations, my thought was that you had wells that were not part of the CPA, that were not having compliance issues. And my thought was allowing those locations to continue to generate revenue to help tackle this plan and these sites. So I'm wondering, can you clarify some of those details?
Yes, I'll do my best from memory. On the latter point first, the McCallum Field wells are in Jackson County. I think there was maybe one location that was under the CPA, but there's active remediation there. There's also a water flood. It's also all on BLM land. I think allowing that to continue to operate, to remediate the active remediation system and to engage in the water flood operations there makes sense. It's not the primary focus of the CPA. The D-sand and J-sand wells and the Codell Niobrara wells that are not on the Spindle Field low pressure flow line system are also really distinct from the Sussex and Shannon formation wells that are served by the Spindle Field flow line system, low pressure flow line system. I think allowing those to continue to operate to generate revenue would make it much more possible for KPK to get into compliance, to engage in shut-in, limited shut-in, we hope, and move forward to compliance without seeing its license to operate revoked. And then was there another part to your question that requires an answer still? I'm sorry, I forgot the first part.
Yeah, I think I'm getting confused about the 901A original list of the director, but that we tackled additional locations in the CPA. And so I feel like maybe when we were trying to I'll speak for myself. I was trying to on the fly, maybe trying to figure out how to ensure that there was revenue coming in to continue to address these sites.
Sure.
Was trying to understand what other locations existed. And I know that you talked about it in your filing. for today. I just can't, I'm trying to figure out if there's overlap with what you're proposing to keep open and what's on the CPA list.
We proposed that the suspension of certificates of clearance only be maintained with respect to the 901A locations that are already shut in. That would allow us to transport gas and oil from all other locations to realize the production revenue to conduct the work necessary to shut in, come into compliance, and to remediate as we're able with that revenue. That's what we confined the motion to.
Okay, thank you for clarifying that. So again, I'm noodling out loud. This not mean anybody else is thinking what I'm thinking. So just asking some questions here. If all of the locations on the CPA list were shut in, that's not 1,250 wells, correct?
No.
So is there still the capability or ability to for KPK to bring in revenue to deal with? I mean, we're asking you, and we've been talking about, I think it's the 70 locations in the CPA. And I can't imagine that we're just going to slice off part of it and say, well, all these wells that you've already shut in, they've already been dealt with, are the only ones that you would have to deal with as part of this conversation that we're having. So I'm wondering if you have thoughts about that.
None as I sit here, Commissioner. It would be speculating on my part. I would need to confer with my client about that.
Commissioner Messner.
Thank you, Mr. Chair. Just a couple of questions from Ms. Stafford, just to make sure that I have my notes correct. I've read your response statement and I appreciate that. I just wanted to understand that it's your opinion that KPK clearly has agreed to the elements within the CPA and has voluntarily signed it. KPK alone is responsible for compliance with the order as presented in the last hearing. It's staff's opinion that it is very much possible for KPK to be in compliance. In fact, the order explicitly creates flexibility to ensure the KPK is able to be compliant with the order and still be protective of public health, safety, welfare, the environment, and wildlife resources. It's staff's opinion that there is no irreparable harm associated with compliance with the order, and that there is a path forward for KPK as a business, and that's to be in full compliance with the order as it's presented in the next 6 months. Is that staff's, am I clear there with staff's position?
Thank you, Commissioner Messner. I think you are largely clear, or you are clear on staff's position, excuse me.
Okay. Thank you.
Further questions from commissioners? All right, seeing no further questions, council, thank you both for presenting this afternoon on the motion. We will now, I think we'd like to just take like a 10-minute break and organize thoughts. It is 4:02. Let's return at 4:12. So we're back and we are in a deliberative station at this point. I might lead off with just some initial thoughts. I'm all right. To begin with, I'm not inclined to grant the motion as is requested in the proposed order. However, having said that, I'm also of the opinion that there is some potential sense to allow KPK's non-problematic assets to be able to generate money so that it can use that to fix and shut in the problematic assets. And I don't know exactly what that means, but I'd be willing to take one stab at it with KPK and staff to see if something could be developed that ensures that this is all cleaned up within the 6-month period that we've been talking about. Having said all that, I also could be comfortable in just denying the motion and letting things shake out where they will. I'm a little bit concerned about that because that just means that, you know, we may end up in other venues trying to address something that we've been working really hard at trying to address. So I guess I would like to get some sense from my fellow commissioners of kind of initial thoughts about where they may be. The path that I could get behind is a short continuance to let myself chat with KPK and staff one more time, although I regret having said that already, having just said that. But I do think it's a prudent, I could get comfortable with it. That's a prudent use of time before we finalize our thoughts on this. Others with thoughts, Commissioner Cross?
Thank you, Mr. Chair. And I have quite a few thoughts here before I kind of get to my overall position. I first want to make a few comments to just kind of clarify some things that were said and kind of my thoughts on some things that were said. First off, I think one of the things that Mr. Jacobs said during his oral argument there was he talked about the possibility of these wells going into the orphan well program. And I want to start off saying, I think that to me is one of the most difficult things about this entire situation is I would much rather have an operator cleaning up these sites than to put more locations into the orphan well program. I don't want to have to put this burden on taxpayers to have to clean this up. And so ultimately, that's one thing that I really struggle with in this. And one of the comments that Mr. Jacobs made was that the orphan well program does not mean that they're going to better maintain the assets. And to me, I think that also signifies one of the disconnects that we're seeing between the operator here and what we're trying to do, because this isn't a matter of who's going to operate these better, who's going to maintain these better. It's not a matter of one being better than the other. It's a matter of making sure that we are protecting public health, safety, welfare, the environment, and wildlife resources. And so that jumps out to me as a problem of, well, we can probably maintain it better than the orphan well program, which I'm not going to go into a matter of which would do it better anyway, but that's not what we should be looking at here. A second point is the whole right size the sanctions comment that was made. And Mr. Jacobs talked about wanting to make sure that the ability to pay was going to have an effect on what the sanctions were. And it's my understanding that, and granted, this was before my time on the commission, but it's my understanding that some of the sanctions were lessened as a result of the ability to pay. And then on top of that, additional sanctions were suspended. But suspended does not mean that they can't be brought back. And that's exactly what happened here. We as a commission found that KPK was not in substantial compliance, and therefore one of the things consistent with the CPA is that suspended penalties could be brought back. And I think that was appropriate, and that's what was done here. So trying to say that the sanctions are inappropriate because of inability to pay, I think is starting to rewrite history. I also want to just quickly note that I found it very problematic that despite a month ago us issuing our oral ruling and 2 weeks ago us having a written ruling going into effect to get rid of the certificates of compliance, KPK appears to be operating business as normal. I recognize that they said they've had some staff resign, they've had some trouble with vendors, but according to staff, they're continuing to sell oil and gas, they're continuing to do things even though we removed those certificates of clearance. And so that's problematic to me. I think overall, with respect to the motion, I'm in full agreement. I'm not inclined to grant motion for reconsideration. And I think on the most simple basis, a motion for reconsideration requires manifest error of law or fact. And here, none of that was shown. And that's why I was trying to ask Mr. Jacobs, what manifest error did we have in our ruling, either legally or with respect to fact? And the only thing he was telling me is that shutting in the wells is going to potentially have problems. That's not a manifest error of fact. That's not a manifest error of law. That's just showing a mere disagreement, which is exactly what Colorado law says is not a basis for reconsideration. So just purely on that alone, I'm not inclined to grant reconsideration. And I think when you actually delve into that a little bit more, there's not even an argument that we didn't consider the potential impacts of shutting in wells, the potential impacts of having to maintain these locations. First of all, our order didn't say, we as a commission did not say, you have to shut this in overnight. And that's one of the things that staff pointed out. And I think they're exactly right. I understand KPK's suggestion that without being able to sell product, they're not going to be able to pay to maintain these things. Without going into right at this moment, the ability to pay or anything like that, that doesn't mean that we ignored any kind of fact or ignored anything else happening. And on top of that, we're also hearing from staff that if the situation should arise that they have to take over for it, they will be able to maintain these wells and these locations. And to me, I think that is vitally important, and there's no basis to overturn on that fact alone. And I think lastly on that point, it's also important to note that we still have to balance them saying that we still have to try and maintain these wells, that shutting in quickly is a problem. We still have to balance that with the fact that we have found that on numerous situations, KPK has not done a good job of protecting public health, safety, welfare, environment, and wildlife resources. Without going back into the hearing, we had wells and locations open for hundreds and hundreds of days, some over 1,000 days, for locations that are simply not being remediated. And to me, trying to balance those things, it's not putting faith back in KPK to go back and do that merely because this was not something that was even arisen as an argument during the previous hearing. With the ability to pay, I'll just make a couple comments. I don't think that there is an ability to pay shown, an inability to pay shown right now. We're going back to stuff that was brought up last June. There's been record profits for a lot of oil and gas companies at this point in time now. They've been paying millions of dollars for Marcom. They've been making all kinds of other payments. This is not something that was brought up in the January hearing. And so trying to go into some of these issues, I think is not, to me, something that should turn the tables on the motion to reconsider at all. And I think also going into the ability to comply, I think something that was not touched on today, but was brought up in the briefing, was the fact that regardless of any kind of situation, every operator in the state has to show the ability to comply with all obligations financially. And so trying to say, well, we won't be able to pay for shut-ins, or we won't be able to do that, and so therefore you should reconsider the prior order that you had, is nonsensical to me, because it's essentially saying ignore the legislation, the Oil and Gas Conservation Act. It's saying ignore your rules and let us continue to operate at least some of our wells so we can continue to try and pay for things, even though we found that they don't have a culture of compliance within KPK, even though we have found that they are not properly reporting spills, even though we have found that they are not taking the necessary steps to try and make sure that remediation of sites for which there are significant problems is being handled in an expeditious manner. And then finally, I want to talk about just briefly talk about the irreparable harm. And ultimately, I think this is something that will likely have to be decided in the courts, whether it's now or 6 months from now. And I, just to get it on the record, don't think that there is a showing of irreparable harm made at this point in time. There's been an implication of irreparable harm. There's been indications that ending businesses in the past is shown to be irreparable harm, but that's not what's happening here. KPK still has assets. If it cleans up its assets and gets back into compliance, it can continue to operate. So we are not stopping their business at this point in time. Further, we are not making it impossible to have a sale. Mr. Jacobs kept talking about the difficulties of having a sale when this would occur, but there is nothing that says it would be impossible for them to sell their assets merely because this order is outstanding today. And the fact that they can still make that sale, the fact that they can still comply with this order, they can still clean up and remediate these sites and start operating again, shows that there's no irreparable harm. They're just not wanting to take the steps to do so. So I think in conclusion, I am not inclined whatsoever to grant a motion for reconsideration. With respect to the points you made, Mr. Chair, and with respect to some of the questions that Commissioner McGowan made, you know, I'd be interested to hear what other commissioners think, but, you know, potentially we could hear staff's points in a week or so and can continue this decision for a little bit of time to understand what kind of plan could be reached, and I'll say in a very short period of time, about potentially keeping open sites that don't have problems now, to pay for cleaning up those sites that do have problems. But I will say I do provide a lot of hesitancy towards that, not because it's something that I don't think can be done, but because it goes back to what Commissioner Messner said before: fool me once, shame on me; shame on you; fool me twice, shame on me. And I don't want to have to deal with that again. And I think because it's ultimately probably going to be something that's going to be before court, I'm tempted to say, let's have it before the court sooner rather than later and get a judicial decision on this, because I'm confident in our ruling, I'm confident in our findings, and I don't think that it's something that should be dragging on because of it.
Commissioner Messner.
Thank you, Mr. Chair. Thank you both, Mr. Chair and Commissioner Cross, for your thoughts. Always appreciated. I mean, I'd like to start by saying that, you know, I don't appreciate that KPK is here today threatening the state of Colorado by threatening non-compliance. KPK has a path to compliance, and KPK alone is responsible for that compliance, and they need to implement the steps necessary to come into compliance. That responsibility is required of all operators in the state of Colorado, and it's required of KPK as an operator in the state of Colorado. I think staff correctly indicates that it is possible for compliance, and it lays it clearly out in staff's arguments. I do not find irreparable harm. KPK agreed to the CPA voluntarily and knew the potential penalties associated with non-compliance. This commission did right-size the possible penalties prior to the development of the CPA, utilizing our rules, and included them in the CPA and therefore in the order. I would agree with Commissioner Cross's thoughts on that matter as well. KPK knew the potential penalties and agreed to them. And in fact, a significant amount of money that's been expended to date on compliance has been expended to subsidiaries of KPK, including Kaufman Wells Services, and so therefore has generated its own revenue through compliance efforts of the CPA up to this point. KPK continues to be out of compliance with both the rules and the order. Staff is correct that the order does contain reasonable and necessary flexibility to ensure protection of public health, safety, welfare, the environment, and wildlife resources in the implementation of the order. KPK is responsible for doing what is necessary to ensure compliance and utilize these elements to protect public health, safety, welfare, the environment, and wildlife resources. Staff also has indicated that they are prepared to step in should KPK fail in their efforts in compliance. In the end, I do believe that, as Commissioner Cross indicated, that there is a path forward for KPK to continue to operate in the state of Colorado. They need to come into full compliance with the order and with COGCC rules for all of its assets within the time allotted by the order. And KPK would have the ability to continue to operate. So for these reasons, while I appreciate Chairman Robbins' thoughts towards trying to work between staff and KPK to see if there's another solution, I do think that it is KPK's burden, should they want to bring forward a reasonable motion, that this commission can consider that, but this commissioner is not interested in putting any additional burden on staff to hold KPK's hand in figuring out how to comply with COGCC rules. And so therefore, from this commissioner's standpoint, I put that burden on KPK. If they want to come forward with another motion for consideration, that this commission is prepared to listen to those arguments. But I believe at this point, I would be inclined to deny the motion that is in front of us.
Further deliberative thoughts? Commissioner Ackerman, then Commissioner McGowan.
Thank you, Mr. Chair. Appreciate that. I appreciate the testimony again here today. My comments are similar. A significant amount of testimony was dedicated to discussion about KPK being outside of compliance on multiple fronts throughout the hearings, which ultimately led us to where we are today. And historically, once outside of compliance, KPK's return to compliance in most, if not all cases, has been one of reluctant dedication of resources, a difficult and argumentative approach with staff, even during the CPA, and progressing toward compliance really at glacial speeds. So even though this approach toward compliance was the key focus of the hearings, KPK continued immediately after the commission order to operate outside of compliance by surreptitiously selling products without communicating with staff, really an immediate continuation of the company behaviors that have caused so much concern and have been the subject of the hearings. Given this blatant disregard, I just would simply not feel prudent if I were to assume that KPK is on the road to some sort of compliance and that 6 more months would improve the situation. I want to restate that this has been a multi-year, many-pronged effort explicitly directed at steering this company toward compliance with COGCC rules, up to and including devising the special compliance plan, which ironically could have and should have been used to do the things we're talking about here today, which arguably would have helped demonstrate substantial compliance and continued that plan. Thus far, we found all the efforts at compliance to be unsuccessful. During the testimony, the director reiterated staff's opinion that we are just, quote, out of tools with this operator, compelling COGC staff to entreat us during testimony to stop the bleeding. And I would agree that ultimately, if COGCC reluctantly does have to assume the responsibility of these facilities, the effectiveness of staff in being able to achieve shutdown is a COGCC issue, not an issue of consequence to KPK, and therefore, not a valid legal argument that disallowing continued operation of KPK is somehow a violation of protection of public health, safety, welfare, and the environment. I would note that COGC staff are experts in the field, and they've stated that they are capable of undertaking this activity if they have to do so, and I believe them. Again, I mentioned during the hearings, I'm worried about just enough compliance from this operator to continue to operate. This approach, in my opinion, is no different. out of the gate, knowingly continuing to violate the order is consistent with the historic approach of this operator. And to me is a compelling argument that the same approach will continue as long as KPK continues to operate. They didn't, to me, demonstrate in their motion nor in their testimony any compelling issue associated with the commission's order. And I would reiterate that I also believe that the order clearly set forth a path to compliance for KPK. And so again, recognizing, Mr. Chair, your always facilitatory thoughts and efforts of wanting to do absolutely everything possible for every company to achieve compliance. I think my preference would be to continue to stem the bleeding and simply deny this motion. What KPK is asking for here today is exactly what they should have been doing during the CPA to demonstrate compliance. I would urge KPK to ensure its future by taking upon itself the responsibility to become compliant and resume operations. Thanks, Mr. Chair.
Thanks, Commissioner Ackerman. Commissioner McGowan?
Thank you, Mr. Chair. And I think that my fellow commissioners have very thoughtfully laid out some very valid arguments about how we've gotten to this place. I think it just feels like business as usual with KPK in that here are some more things that we want to do that we haven't been able to do time and time again. Let us do this, let us do that. I mean, if a shut-in plan takes 10 to 15 days, KPK should have that plan in place and be sharing it with the commission and saying, this is our shut-in plan, and here's why we need more time, and here's how we're going to put it together, and here's the timelines. It's concerning to me that they're just talking about shut-in and they're not talking about any sort of kind of compliance remediation, repairs, reclamation as part of this plan, this unknown plan that they've put forth. To me, this problem is bigger than the 901A projects that the director had to deal with, before it could come to the commission, because she was so concerned about the environmental consequences of these locations. I have to ask myself, is the irreparable harm due to the fact that KPK is unable to follow the rules? Other operators can follow our rules and don't go out of business. There is no irreparable harm there. They have figured out a way to follow our rules. And so I'm struggling. I think the irreparable harm is on themselves. That being said, I would prefer that the operator take care of these sites instead of the state having to do it. But there's a reason that we have the Orphan Well Fund, and it's when we think that operators are unable to comply and unable to take care of their resources. And I think that the many hearings that we've had with this operator have shown that we are at that place. So if that's what has to happen, then it has to happen. But I would note also one way to avoid having to shut in all those locations is the operator getting these locations into compliance. They wouldn't have to shut in, they could continue to produce product. So those are my thoughts.
Thank you. Thank you, commissioners. I appreciate everyone's deliberative thoughts. At this point, I would call for a motion. Commissioner Messmer.
Mr. Chair, I would move to deny the motion for reconsideration as presented.
Do we have a second?
Second.
Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion to deny the motion to consideration prevails. At this point, I do not believe we have anything further before commission, so I would be looking for a motion to adjourn.
So moved.
Second.
Second. Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
Thank you, everybody. We are adjourned.